Thank you, sir.
very much.
Okay.
Thanks, Bill.
The next speaker is Mr. Wright, and after Mr. Wright is Mr. Gardner. Mr. Wright? Members, Mr. Wright's representing the Environmental Water Caucus, Friends of the River, and Restore the Delta, right?
Yes, Mr. Chairman.
Thank you, sir.
Good afternoon, Mr. Chairman and council members. My comments go to the recirculated draft environmental document, the Delta Plan, and the regulations. Approaching this in part from a legal perspective, it's necessary to consider all of the documents that are out there because, of course, the environmental impact reports, what they address is the project, and the project in this case is your plan and your regulations. And I've got a number of points to make, and the first one thing that really jumped out at us is the double whammy of at this time calling for new conveyance upstream from the Delta. And we all know from what's going on with the BCDP, the Delta tunnels, that's a major new conveyance. They're talking about twin tunnels with a capacity of diverting 15,000 cubic feet per second out of the Sacramento River in the Clarksburg vicinity and taking it around to the Tracy pumping plants. They have said that they claim they've scaled it down by calling for 3 intakes instead of 5, so the intakes would be capable of diverting 9,000 cubic feet per second. But, I mean, the tunnels, they're 35 miles long. They're going to cost billions of dollars. Obviously, you would only build tunnels of that capacity if that was the water you eventually invented to take, and it would be very easy to add 2 more intakes down the road. And we submit, with all due respect, that's what must be considered under CEQA, our environmental laws. The thing that jumps out is in your own plan at page 80. There is some candor there, and it says that as a result of climate change, we can see sea level rise as much as 55 inches by 2100. And it says that that will result in high salinity levels in the Delta interior, which will impair water quality for agriculture and municipal uses and change habitat for fish species. So what just jumps out as being absolutely astonishing is recognizing that we all know that the Delta already has a problem with salinity intrusion from the bay. The plan has statements in it where it recognizes and candidly does admit that a lot of that is due, of course, to the already extensive diversions of water from the Sacramento River and from the Delta. In light of that, to add massive new, call it new conveyance, improved conveyance, optimizing diversions in the wet years, it just looks like creating a massive double whammy, kind of a two-front war for the Delta, facing a surge of salinity intrusion from the bay, and at the same time taking out the fresh water upstream from the Delta. Now, if you went instead with the alternative that the Environmental Water Caucus has called for, which you've numbered Alternative 2, to maintain through Delta conveyance and continue pumping from the South Delta, at least the fresh water that the exporters take remains in the Delta. It's there to be used to help fight pollution, help fight salinity intrusion, help protect agriculture, commerce, and endangered fish species before it's taken. And what that also does, it keeps everybody on the same page, and that the exporters, like the Delta itself, do have some interest in trying to win the war against salinity intrusion in the Delta, because they also are presently taking from the south end of the Delta. If this new conveyance that your plan is and regulations encourage and recommend, if that comes about, then the sky's the limit. The exporters would be taking water upstream from the Delta. They would not be affected by salinity intrusion, and the delta would be left to face this on its own. And as I said, you have to kind of look at all of your documents together. In your recirculated draft EIR in section 3, at page 3, it does make this generalized admission that operations of new water supply facilities, such as pipelines, tunnels, canals, water intakes, or diversions, may create long-term changes in local mixtures of source waters within water bodies. In my book, in my experience, that might pass muster under CEQA as an initial statement, where you start out the process, or initial study. What are the issues that we need to address in our EIR? That is far too general. It doesn't mean anything. It doesn't tell us anything about the extent of the changes, the severity of the impacts. It just doesn't pass muster in an EIR. An initial study, maybe, not in an EIR. I'd like to turn to the next subject, a little bit related. In your recirculated environmental document in section 2 at page 24, there's some very vague information on funding and mitigation. And what we think the situation is that these massive diversions of fresh water upstream from the delta, of course, they would threaten turning the delta, which is already in danger, into a polluted and salty wasteland, but that the exporters wouldn't be paying to fight that problem or attempt to mitigate it. That would be stuck on the taxpayers and the business and agricultural and fishing interest and the delta itself. We think that's wrong, and we think if you're going to encourage this kind of diversion of water upstream from the delta, then the exporters who would be taking the water and benefiting from it, the only right and just thing to do would be to have them pay for everything caused by what they've taken. Now that's kind of a policy view, but there's also a legal issue there under the Endangered Species Act. The Ninth Circuit recently came out with a decision in Center for Biological Diversity versus United States Bureau of Land Management. It's called the Ruby Pipeline case. We're citing it in our written comments. I'll be happy to furnish citations orally if you want me to. Otherwise,
It'll come in the written version.
It'll be in the written version.
Thank you, sir.
But there, they've made it real clear there's no discretion under the Endangered Species Act to authorize a project that would jeopardize survival of listed fish or adversely modify critical habitat. And also, mitigation measures, they must be there, they must be real and assured. And what I said earlier about the exporters trying to shift the cost of attempting to deal with the massive destruction these massive diversions would cause in the delta is that bond measures have already been pulled from the ballot twice, 2010, 2012. So there's obviously no certainty that the people, the taxpayers, are going to pass bond measures to pay for this. And so we believe you have a real legal problem under the Federal Endangered Species Act and the decisions under that if you don't require absolute, as part of the project, they mitigate, they pay for everything. The next subject I'd like to turn to is your plan, and it sounds, I can see the appeal to it. It calls for optimizing diversions in wet years. And that's mentioned in your plan at page 72, also at page 111. But a different part of your plan at 84, page 84, recognizes the adverse impacts that result from reducing the flushing of San Francisco Bay by delta outflows. And I've got a document that I'm going to give after I've spoken to Angela of your staff to put in the record. It's a technical memorandum 2010 by the Contra Costa County Water District where they did some studies showing that the historical flushing of the delta with fresh water is no longer occurring, This lack of flushing can also allow waste from urban and agricultural development upstream and within the delta to accumulate. And contaminants and toxics have been identified as factors in the decline of the delta ecosystem. What that means for you and what's required in your environmental documents, instead of just coming up, well, we have this idea we're going to optimize, meaning increase diversions in the wet years, that has to be analyzed. There has to be environmental analysis of the extent, the severity, and adverse environmental consequences from further reducing the already reduced necessary flushing of the delta and the bay. And we've looked, we've scrutinized, we haven't seen a peep about that anywhere in your environmental documents. The next subject I'd like to spend a moment on is just the backwards description of the project purpose in conflict with the water code. Your recirculated environmental impact report claims that the revised project will lead to reduced reliance on delta exports. That's in the executive summary at page 2. Your plan at page 72 admits that the Delta Reform Act established a new policy in the Water Code of reducing reliance on the Delta and meeting California's water supply needs. So we can understand why the claim is made. But when you look at the undisputed facts, when you talk about creating massive new conveyance and intake structures that are projected to cost around $14 billion, that isn't reducing reliance on the delta. That's increasing it. That's a huge, expensive public works project. And what we call upon you to do is either, well, drop the call for new conveyance, improved conveyance, anything other than maintaining existing through delta conveyance, or require your EIR consultants and preparers to candidly set forth that this would not reduce reliance on the delta. The truth is this would increase reliance on the delta. And that's what we call upon you to do, is either drop it, that's our first choice, but if you don't drop it, require candor and serve the people and all of the folks involved in this and interested in it with a really candid admission, because that's the kind of thing that it just, nobody's really going to buy that. It's just kind of like if I was to claim right now that it's nighttime outside. Well, it's not. It's daytime. Anybody could say that, but it doesn't make it so. And in fact, in your recirculated environmental document, in section 24, at pages 13 and 14, there that sets out that when you use resources, you make a large commitment of resources, that makes removal or non-use, therefore, unlikely, and generally commits future generations to similar uses. So in other words, if you build it, it's going to be used, and that's going to be increasing reliance on the delta, not reducing it. I appreciate your attention and listening, so I'm going to speed things up and skip over a point.
Okay.
I'll make that in writing. I have till Monday to do that.
Thank you, sir.
Well, it's much appreciated. Much appreciated. This one, your recirculated environmental document makes some very general admissions of significant adverse and unavoidable impacts of the revised project, including its call for improved or new conveyance. In section 24 at page 10, there's just this general line that says significant and unavoidable impacts of the revised project would include water resources, violate any water quality standards or waste discharge requirements, or substantially degrade water quality. Again, it's admitting the obvious. It is true. It's so general. It's absolutely meaningless. And you also include on the same page, page 10 of section 24, the statement that the significant and unavoidable environmental impact would include biological resources, including substantial adverse effects on sensitive natural communities, including special status species, substantial adverse effects on fish or wildlife habitat. That's true. Again, it's so general to be meaningless. And what I and all of the organizations I'm here representing are saying to you for the first time this afternoon is your draft DIR and your recirculated draft DIR under the law are so fundamentally and basically inadequate and conclusory in nature that meaningful public review and comment have simply been precluded, and that under CEQA guidelines section 15088.5A4, it is necessary that you prepare, in order to comply with the law, a new draft DIR and recirculate that for public review. Because just think about it. What does that tell anybody that, our revised project we've chosen will violate water quality standards and substantially degrade water quality? Okay. What standards? By what pollutants? To what degree? How severe will it be? There's a huge difference between a person catching a cold and, unfortunately, having a terminal illness. It's like day and night. Your environmental documents that your consultants have prepared, they don't give a clue. Again, maybe it would pass muster as an initial study starting the CEQA process, not pass muster as an EIR ending the CEQA process. This next point is really very, very important, and that's the absence of information and analysis supplied by your environmental documents. And again, there's a case cite in the written comments. The name of the case is Vineyard Area Citizens for Responsible Growth versus City of Rancho Cordova. It's a 2007 California Supreme Court case. It's a CEQA case dealing with water supply issues that frankly paled in significance. That was for a development project to the water supply issues here. And the California Supreme Court made it clear that the EIR must provide facts that allow the reader to evaluate the pros and cons of supplying the needed amount of water, must analyze the environmental impacts of utilizing the particular sources of long-term water supply, and that the key is that an EIR that neglects to explain the likely sources of water and analyze their impacts, but leaves long-term water supply considerations to later stages of the project, does not share the purpose of sounding an environmental alarm bell before the project has taken on overwhelming bureaucratic and financial momentum. And that's absolutely what we're concerned about here. Delta Plan calls for new and improved conveyance. Then the BDC process, they finish Delta tunnels. And, oh, by the way, this is consistent with the Delta Plan because the Delta Plan called for new or improved conveyance, and that's what we're doing. What I would say to you, Mr. Chairman and council members, that you're in a historic position. I would submit to you that the state water resources should be going first to do its analysis under the public trust doctrine, cost-benefit analysis, determine water availability, and get all that worked out before you enact the Delta Plan or the DWR comes up with the BDCP. But you apparently are first in line, at least right now. And what I would submit to you is that in order to comply with the law, you have to insist that that kind of work and analysis all be done before you call for new conveyance, either by having the work done yourself, and you may not have the resources to do that, and really everybody kind of thinks that's for the State Water Resources Control Board. Insist then that they do it before you call for new or improved conveyance. there's something else that is hugely important on this. Your draft DIR, and by the way, Section 23, dealing with the BDCP, was incorporated by reference by the recirculated draft DIR. And since it's incorporated by reference, I'm going to comment on that. And at pages 3 and 4, they actually did a good job of saying what had to happen under CEQA. They said the BDCP must comply with CEQA, including a comprehensive review and analysis of a reasonable range of flow criteria, rates of diversion, other operational criteria, requirements and flows necessary for recovering the delta ecosystem and restoring fisheries under a reasonable range of hydrologic conditions, identify the remaining water available for export and other beneficial uses, consider a reasonable range of delta conveyance alternatives, including through delta, the potential effects of climate change, including what I mentioned earlier, that sea level rise up to 55 inches, and possible changes in precipitation and runoff patterns, and so forth. Your draft DIR was correct on that, on what was necessary. What stands as an undisputed fact that you have to, well, you're going to do what you're going to do, but I would suggest to you, you need your consultants and attorneys to make sure is done, is to recognize an undisputed fact that simply did not happen. What had happened was in your draft DIR at page 3, they had anticipated that a public draft of the BDCP and related EIR, EIS would be released by mid-2012. Simply didn't happen. And Deputy Director Jerry Merrill just said at the last public meeting in December that even the non-public draft's not going to come out till around February, and the public draft is not going to come out until the spring of 2013. What I'm telling you is that by proceeding now to adopt the Delta Plan and regulations calling for new conveyance, since that work that they thought was going to be done didn't get done, the process kind of would stand indicted and convicted by your own draft DIR. And that's a pretty a serious problem. Again, our point is that some public agency has to do this work under CEQA, the public trust doctrine, before new conveyance is called for. That's the most important part of the whole decision-making process, whether or not to build or not to build or not to build new conveyance. That's huge, and that's what has simply been absolutely overlooked, just treated as a given, an ipsy-dixit, or an assumption. And that jumps into my next point, not now, not ever. Back in May of 2011, the National Academy of Sciences, when it was reviewing the draft BDCP plan, said that choosing the alternative project before evaluating alternative ways to reach a preferred outcome would be post hoc rationalization. In other words, putting the cart before the horse. Scientific reasons for not considering alternative actions are not presented in the plan. That's still true today. Scientific reasons have not been considered and evaluated for not considering alternatives grounded on not building and developing new conveyance. There's another problem with your recirculated draft EIR is between your last environmental document and the recirculated one, the federal and state fishery agencies came out last year with their red flag warnings. We scrutinized your recirculated environmental impact report, didn't see a clue about that, and didn't see a clue about the National Academy of Sciences determination that scientific reasons for not considering alternatives have not been considered. What I would say to you, and again, I do appreciate it, and I'm wrapping up.
Thank you, sir.
Thank you. 2 or 3 more points. But I'm trying to help here because we know we face a stacked deck with the BDCP. the exporters want the water. They're in control of the process. Our hope is, we got hope in two places. One is the State Water Resources Control Board with board members, and another is your council with different members on it. And substantial evidence includes things like facts, reasonable assumptions predicated upon facts, expert opinion supported by facts. Argument and speculation and narrative doesn't meet muster under CEQA guidelines section 15384. And I would submit to you that everything that's been done so far in calling for new conveyance, calling for adopting the revised project alternative, and fails to address and analyze the admitted significant adverse impacts on water quality and endangered species in the Delta is simply that, argument, speculation, narrative, and doesn't pass muster. Same is true, your circulated environmental document in section 25 at page 17 says that alternative 2 submitted by the Environmental Water Caucus is slightly environmentally inferior to the revised project because it would sharply reduce exports from the Delta, potentially creating a supply shortfall. Stating potentially, again, that's mere narrative and speculation. We would say again is on a number of points that it's necessary to prepare a new draft EIR and recirculate because the draft and the recirculated document out there so far have simply been too inadequate and conclusory to furnish informed public review. On a different subject, you have an absence of an accurate, stable,
I'm
and
going to have to give you no more than 5 minutes, hopefully less than that.
It's appreciated.
Thank you.
And that's fine. And on the project description, there are very vague things in your environmental documents in section 2 at page 5 talking about surface water projects, conveyance facilities. In section 2 at page 26, you say that the revised project would not have direct impacts or directly result in construction, but could, however, result in or encourage implementation of actions or development of projects. But since your draft document was out, the Deputy Director, Merrill, said what this project is in June of last summer. The two tunnels, 35 miles long, 15,000 cubic feet per second. The governor confirmed that at his special press conference in late July 2012. And I would say to you that CEQA's informational purpose is not satisfied by simply stating information on the details will be provided in the future. And again, that's in that Vineyard area citizens case. Last couple quick points is we heard some talk about economics and costs. Your recirculated EIR should have disclosed and discussed the University of Pacific cost-benefit study that came out in July showing that the cost of the Delta tunnels would be 2.5 times higher than the benefits, so that the project doesn't make economic or financial sense, because in terms of the public comparing alternatives, that is relevant information to know that in addition to all of the environmental reasons to not go forward, the project also is a bad deal when you look at the cost-benefit analysis, and I'm going to give that to Angela as well. A final point is simply there's been a failure to evaluate upstream impacts. Your Delta plan recognizes changes in storage and flows for fish at pages 80 and 91. This plan would have this project, new conveyance, would have enormous impacts requiring changes in reservoir operations upstream, affecting minimum flows, storage, so forth, for fish presentation purposes. I would simply wrap up and conclude by saying that the first step in this whole deal is whether to call for new conveyance. That's a huge deal. That's on your plate. What we do is we object to approval of the plan and regulations insofar as they call for new conveyance, optimizing diversions, improve conveyance, and say that it's necessary to do the work, do the analysis before calling for that. We do think that calling for new conveyance would start the journey that we believe would strike the last nail into a coffin for the Delta. That's why we're fighting so hard to try to get that from happening. Thank you. I'll leave my contact information with your staff and submit the exhibits to Angela. And the written comments of the Environmental Water Caucus, you'll receive those on Monday.
Thank you very much.
Thank you.
Okay.